Hello, I'm Vince White. I'm an employment attorney, and on this channel, we answer publicly posted questions from YouTubers, getting them the answers they need from an employment attorney. We have a question here from the aptly named Queshypoo305, which I assume is a reference to Winnie the Pooh asking a question. Queshypoo305 asked 4 hours ago. Queshypoo says, "Love your channel." Love your taste, Queshypoo. Queshypoo goes on. A coworker had the following scenario, and I'm curious about it. What if an employee engaged in the interactive process with the employer, which would be the interactive accommodation process, then HR in a meeting said their disability was not real. The employee stops the process, then re-engages a few weeks later, but refuses the in-person meetings and requests that be handled through email, which HR allowed. There was a major safety incident, which the employee reported prior and re-followed up on, now the PFMLA, so I assume that is Paid Family Medical Leave Act time, which is not a federal law, but is a state law. And the PFLMA is being utilized to meet the immediate ADA need. Requested months ago and followed up with no response prior. Was denied the day after the complaint of safety. The accommodation offered was literally what the doctor said no to, and although others were allowed to use their PFLMA for reasons similar, they were told if they used it, they would be fired. Management then bullied and publicly shamed her in front of coworkers until she quit. Okay, so really quick, I'm going to assume there's a real disability here. And I'm not playing the game where, like, some disabilities aren't real. Some disabilities aren't diagnosed. So if you're, like, writing yourself a little doodle being like, I'm a triple amputee, which I'm not mocking amputees, but, like, I'm mocking the idea that you would write this for yourself when you're not an amputee, right? And you're just like, so I deserve an accommodation. And anyone who looks at you can see that you're not an amputee at all, and they're just like, hey, that's not real, right? Or the other way for a disability to not be real is for you to have a diagnosis for something that's not protected under the laws in play for you. So if you only have the federal laws, we have a pretty good idea of what counts as a disability under the federal laws. If you have something that does not historically count as a disability under the federal laws, your employer could perhaps say that your disability is not real. And what they would mean is it's not real in terms of their legal duty to accommodate, to engage in the reasonable accommodation dialogue with you. So let's set those aside. Those are separate situations, and they sound a little ridiculous, but let me assure you, it happens. There are certainly disabilities that are not that are real disabilities that I believe in, that are not given the same protections under the federal laws, and there are certainly disabilities that have not been diagnosed by a doctor that might be faked by an individual who just wants an accommodation. That happens too. I see that plenty. Let's chuck those over there. We're going to assume the disability is obviously real here because it seems like it is. So right off the bat, when HR says the disability isn't real, go talk to an employment attorney. Go talk to 3 to 5 employment attorneys. Schedule free consultations with 3 to 5 experienced employment litigation attorneys. You already may have a claim. Certainly you have something worth talking about. Now, that's not what this individual did. This individual waited a couple of weeks and then re-engaged in the reasonable accommodation dialogue. Presumably, it seems like with a letter from her doctor. And going through that process, it sounds like it did not go well. It sounds like they offered accommodations that the doctor had said would not work, and that is all they offered, even though other individuals with other disabilities received the actual accommodations this individual is asking for. Now, listen, that's an interesting thing to say, right? Because different disabilities require different accommodations. So just because somebody has another disability, a different disability, and they get PFLMA, which is essentially leave time, paid leave time, it doesn't necessarily mean that this individual, this plaintiff, she would receive the PFMLA as well. But it sounds like the PFLMA here was the appropriate accommodation, and other people with similar disabilities had already received it. So it would stand to reason, we're assuming, that she should have received it. And then there's this weird event where there's like a safety issue that our heroine, the hero of our story, reports, and all of a sudden she's, persona non grata. They're out to get her. They want her fired. Now, this complicates things because now we have a disability discrimination case that was fairly clear cut. But we also now potentially have a whistleblower case or a workplace safety and OSHA claim of some kind. And that's good and bad. It's good to have more claims if you have to sue your employer, but it's sometimes bad because, you can say, hey, this is all because of disability discrimination. And then the employer's like, well, but you said it's because of the OSHA violation you reported. You said you're an OSHA whistleblower, so which is it? And that can make things a little bit complex. Now, listen, you can deal with that. Trust me, it's not the end of the world. And you want more claims rather than fewer claims, but it is a little more complex. And there's, on the tail end of this, right, they bully this individual and they shame her in public. That retaliation claim is very complex. Because are they doing that because she sought an accommodation? Or are they doing that because she reported a workplace safety issue? I don't know. It sounds like Queshipu, who's posing the question to us, who is the third party, not the individual it's happened to, also doesn't necessarily have a firm opinion as to why this individual, why she was publicly shamed and bullied and driven from this job. Now, that makes me very much not jealous of the young associate who has to draft this complaint, because it's a claim. There's claims here. This person should absolutely speak to an employment attorney, but which is it? Now, I know which we want it to be. The ADA claim, the Americans with Disabilities Act claim, under the federal law, and whatever state or local laws you might also qualify for, is almost certainly going to be more valuable than an OSHA claim. OSHA, great agency. Very overworked, very overburdened, tough to count on, and claims that go before OSHA, not always the most valuable. They don't always get the most attention. So, not ideal to have to bring your claim to OSHA. Not the dream. Would I rather be in federal court with an ADA claim? Sure. Do I think that claim is worth more? Yeah. Do I think it has a higher chance of recovery? I sure do. I think it has a higher chance of settlement. I think it has a higher chance of winning before a jury. I think it is significantly more valuable, statistically speaking. And I would, without question, rather bring the ADA claim. Now, can you just bring the ADA claim? I would argue yes. You don't have to pursue all your claims. Do you want to pursue the OSHA claim? I mean, maybe you do, maybe you don't. That's a tactical decision. I think we need to know a little bit more about the situation. Listen, OSHA claims can apply a lot of pressure. There's reasons to bring the OSHA claim. It's not simple. It's not a simple decision. It muddies the water, but it gives you extra leverage. Good luck making that decision. It's, I don't have to make that decision. I'm just a guy on the internet. I'm not the attorney running this case. Generally speaking, I err on the side of more leverage. But we're a premium firm. We put extra hours in, and you don't pay us by the hour. So, it's our joy to put the extra time in. But it does make things more complex, and it really multiplies the work that your attorneys are going to have to get into. It might even, believe it or not, might make it harder to get representation, because attorneys don't want OSHA cases. Many employment attorneys are actively disinterested in bringing OSHA claims for the reasons we discussed earlier in the video, kind of when we were discussing OSHA and, how overburdened and often inactive they can be. And often their claims are not worth the most, right? So you get a lot of firms hear the OSHA claim and just kind of discount. Like, oh, yeah, I don't think we're interested. That could be tough. Now, the ADA claim sounds great. Sounds like a failure to engage in the interactive process. Sounds like a failure to accommodate. Sounds like potentially a retaliation claim. That's a lot. That's great. Love that claim. Take that claim any given day of the week. But a lot of firms going to hear that OSHA claim and say, no, thank you. Believe it or not. So, Queshipu 305, that is my breakdown of your scenario. I hope this helps your coworker in some way. Thank you for your question. I hope my answer was helpful. If it was helpful, like, subscribe, comment down below. Share our channel so that it may grow. If it was not helpful, if I failed you in some way, if I misunderstood your question, tell me in the comments below. I will try to make a follow-up. Wonderful. Take care, everybody.